Besigye.
Omulamuzi Akawangamude. Tetugenze kooti abatuyise kooti etandika. Nati yagiro. Aluddewo. Sefuma dokita bakamuleeta essimu gy'ombulizizaako gyenkolerako. Dokita yakayingira kooti kati. Kityawo. Ne luli yatuyita. Ayagala funa wakuyingira.
Media people, worship the leaders in the first one. The chambers. All media.
Hello, Judija.
All media, please. Let's do that one very fast.
Because there are many. Unless you're saying you say every individual. That's what. When you say media house, then one will go and one will remain. So say every individual. Koze musajja oli yani mwerabira abantu kansoko F3 obozi bwogera abantu ye
Yes, please.
For the defense, humbly pray that senior colleague also our areas for this, so we do not omit anybody.
I think they should sit. Yes, but we're starting with the application.
Indeed.
So F3 shouldn't be part of them. You should sit. Yeah, you should.
It was in a corner there.
Yeah, but is it in order for him to be standing when he's not part of it? Or if there's a chair there, you can sit and, don't necessarily take part in this.
May I proceed?
Yes, please.
Worship, for the defense, humbly pray that senior colleague also our areas for this, so we do not omit anybody.
It is you, your worship. My name is Rebuttal. Appearing together with Frederick Panda. We have Farouk Kamrege, Katumba Apollo, Kanjako Abubakar, Ryan Inawe, silence. We are ready to proceed with the application.
For reconsideration. If you can check, choose the applicant. Prosecution is required. The applicant. However, last time when we appeared in court before, in respect to this matter, counsel for the respondent applied to this court to have Mr. Diego Benedict who defound the affidavit for the applicant to appear in court we presume for cross-examination. And court okayed it. However, your worship is a prayer by the prosecution that Mr. Diego Benedict, police officer and one of the investigating officers in this matter, is a key person in these investigations, which are still ongoing. And is appearing before court, which has no jurisdiction to hear this matter substantively, but has jurisdiction to hear this application. My Lord, before this court, at a press. It is for that reason, Your Worship, that prosecution, the applicant, raised to this court to have the application heard in chamber. This will ensure, one, protection of Mr. Odiek Benedict from public attacks. And the threats which are imminent, Josh, this court is a witness, and here the singing and everything. So therefore, subjecting having this object before this court will jeopardize his security. As if that's not enough. As if that's not enough, it would jeopardize the investigations. Because it's still one of the investigating officers in a matter whose investigations are still ongoing. Your Worship, under Article 23, Clause 2 of the Constitution of the Republic of Uganda, 1 and 2 actually. Allow me to read them. Under Article 28, Clause 1, Your Worship, it is stated that in the termination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. And 2, that nothing in clause 1 above of this article shall prevent the court, in this matter, this honorable court or tribunal, from excluding the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as may be necessary in a free and democratic society. It is a submission, therefore, that our application passes the test under Article 28 to protect custodian and integrity of the investigation. Given the nature of the offense and the people and the nature of the accused persons or applicants or respondents in this matter. This application is brought in good faith. It is brought in good faith, and in no way shall the rights of the respondents be denied. And Your Worship, the Constitution provides the categories of people who can be excluded, and it says, our submission that we exclude both the public and the press. This is not a substantive trial of the respondents. But even then, even in substantive trials, this court is enjoined with the powers to do away with the public and the press. Your protection of the witness or an investigating officer who will be a witness in the main trial at this stage is something that is paramount. And it is the duty of this court and all court officers of court to execute that role. There are other cases, Your Worship, when in the trial, for example, where courts have hinted on the importance of protecting witnesses and evidence at large. I'll not go into the details of that case, but I just want to quote it for your record. The constitutional reference number 6 of 2007 Sun Yen Kong Pin and another Sun S-O-S-O-N, Yen is Y-E-O-N, Kong is K-O-N-G, Kim and another versus Attorney General. My senior colleague Banga was part of that case, fortunately. But among the principles was a principle of protecting witnesses and the evidence we are held to be very, very critical. And Your Worship, it is our prayer that the reasons we have advanced are enough, Your Worship, to have this matter tried. Hard in the chamber.
Your Worship, in response, first of all, it is true that we were party and counsel in the Sun case, which the Land State Attorney has alluded to. What he hasn't told this court, and perhaps for reasons known to him, is that what was sought in that matter is what he was seeking, is what he's seeking now. And the Constitutional Court dismissed those arguments. The court found that the rights of an accused person are paramount. And Your Worship, the court took the view that in a criminal trial, the entire state causes facilities to go down onto an individual, and that their rights cannot be compromised for the benefit of the state. And Your Worship, in that case, which again my colleague has referred to but has not told you the full facts, is that the court allowed a full disclosure of all material, including statements and the identity of the people who make statements, who essentially are the witnesses. Reason being that the accused person must be availed all facilities to prepare their defense. And that is in Article 28(2). C. Your Worship, it reads, at 28(3)(c), every person who is charged with a criminal offense shall be given adequate time and facilities to prepare their defense. Your Worship, cross-examination of an individual purporting to read evidence against an accused person is part of the facilities according to the accused person. Your Worship, my colleague also referred to threats, which he said constitute singing. Your Worship, it is strange because all of us sing. Even him, he was singing, yet I didn't feel threatened when he was singing next to me. But again, we note that even if he says singing is a threat, perhaps the songs that were sung were at a time when the witness was not known. So I doubt that the witness is the one who has told him that he was threatened by the voices in the song. But Your Worship, the point we also want to make is that the state has got very many police officers. And under the acts which this application is grounded, the Computer Misuse Act, and the Data Protection Act, it refers to any officer. It does not specify that it must be an investigating officer. So the state had the opportunity to invite any of these several officers. But the state chose to bring an investigating officer. It is clearly not the fault of the accused person who is in custody. It is therefore wrong for the state to try to recover where it slipped in this application at this stage. Your Worship, in any event, the identity, because I understand Mr. Billy Vumbuka to say that they want to protect the identity of the witness. But Your Worship, the identity of the witness has already been made public in the application, which is supported by an affidavit that has his warrant card with his photograph and even number. So the information the state wants to keep private, whatever means, is already public. Moreover, those details about the witness have been repeated by Mr. Billy Vumbuka himself here. He said the witness is a police officer and the IO. He even mentioned that his name is Odiek Benedict. So we don't want him to state his identity. We want him for evidence. So if it is protecting identity, Mr. Billy Vumbuka has already given it away. That he has done so surely means that the identity of the witness was not perhaps important to be kept private. Moreover, Your Worship, even we counsel can record and are not restricted from saying what the witness shall say to the public, because we are not bound in confidence by these proceedings. We can even draw him here and present his picture, the artistic version, to the public. That is a belated attempt to cure Mr. Besigye's sleep. And perhaps, Your Worship, he said he wants all members of the public out. Your Worship, the first member of the public in the city is the Lord Mayor. So even we lawyers are members of the public. So perhaps by saying he wants all of us out, he wants the benefit of having the accused unrepresented, which is wrong. He knows it. He did not say excluding the lawyers, he said all members of the public. The assumption is that for him, he's not a member of the public. The other point, Your Worship, is that Article 28, 1 and 2 was rightly cited by my colleague. The emphasis is in Article 28, sub-article 2. Nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press from all or any proceedings before it for reasons of morality, public order, national security, as may be necessary in a free and democratic society. Your Worship, that article comes after the right, the presumption being that criminal proceedings should be conducted in the public view. And Your Worship, that stems from Article 126 of the Constitution, which says that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people, in conformity with the law, with the values, norms, and aspirations of the people. Your Worship, the aspirations of the people is that their leaders must be tried in an environment where they can see that proceedings are fair. That is one of the ways in which the judiciary accounts to the people in exercising judicial power. That trials are not conducted in camera because anything can happen in camera. So before the nature of the provisions of sub-article 2 require that before the right to be tried in public view is removed, the state must demonstrate with tangible evidence that having the press and the public around is contrary to morality, public order, and national security. Your Worship, that requires that the state presents tangible evidence in the form of an application supported by an affidavit, in which it is shown that if the public remains, any of these three will result. Your Worship, it is wrong for Counsel Billy to purport to bring evidence from the bar that there will be national security will be compromised. He has made an allegation which is not substantiated in any way. And perhaps for that matter, after our submission, before he responds, because he's now brought evidence, we shall ask that he be cross-examined about national security. So that he stops talking loosely in a forum like this one. So, what we are saying is that there must be tangible evidence in an affidavit. And Your Worship, we need to remember that in the most discreet society, which is the military, in the general court martial, even the public was allowed. And in the affidavit of Mr. Benedict Odiek, he says the proceedings in the court martial were handed over to the civil court. So it started as a public trial. The allegations of Mr. Billy Bumbuka are unfounded. And apart from mentioning national security, which he has raised, he has not stated anything about national security that will be compromised. I want to believe that he spoke about it erroneously. We want to conclude. We are saying that a criminal trial is in the public interest. The interests to be balanced are that of the state and that of the accused persons and their relations, not the state's interests only. So taking away the interests of the accused persons must be in exceptional circumstances, which have not been demonstrated at all in tangible evidence. Mr. Billy Bumbuka is not on oath, just saying things. He also said that to prevent Mr. Odiek from presenting his evidence or being cross-examined is necessary because of the accused persons involved. He's now purporting as the state talk about the antecedents of the accused loosely. He has not brought evidence, and we don't know how much he knows about the accused person. It's a problem of speaking loosely. So you want, because this is a public court, that is why we are here, and that is why this hearing was announced. This court can only fully account that this trial is in the public interest, meets the aspirations of the people, is fair and impartial if the people from whom it derives power see it in action in real time and life. We therefore pray, for my colleagues may want to add, that the application, which is based on hearsay, is dismissed in its entirety, and we proceed with what brought us today. Because my Lord, you shall be reminded that Mr. Billy Bumbuka who said that this application was urgent. You can therefore put roadblocks, should dispense with it, and move on to the next step. Worship, my colleague wants to add something before the state can respond.
I join the issue with my colleague in objecting to the application on account of being frivolous, vexatious, And in our opinion, not only responsive, your worship, amounts to an abuse of court process and a grievous abuse of court process. That we should substantiate. First of all, your worship, the state ought to have made a formal application. A formal application supported by written evidence in form of an affidavit, substantiate all the issues. What my colleague said in context of. And I'm fortified in this submission, Your Worship, by the authority of the High Court in the matter of Uganda Reporters Association, Uganda Court Reporters Association Limited versus the Attorney General. It was a cause for judicial review. Miscellaneous cause number 87 of 2014, where again the state had made attempts to exclude members of the press from covering criminal proceedings. And it's such an instructive decision because it brings out two critical aspects. The rights of an accused person to public justice. There's that notion of public justice, which was, I think, initiated in that particular decision. Not technical justice, public justice. In that case, the trial judge, Justice Lydia Mugambe, may the good Lord protect her wherever she is, quoted with approval the case, the East African case of 3-4 Madrid versus R 1960. And this is in the East Africa Law Report 1965, yeah, East Africa, where it was held that justice should be done openly, save in special circumstances for which statutory provision to the contrary is made, and to save in certain, rather unsafe in certain other very unusual circumstances. It's better that a man should not be brought to justice at all than justice to be done to him without the public being given the opportunity of seeing it to be done. I beg to differ. This is the principle. It is better that a man should not be brought to justice at all than that justice should be done to him. No, it's better that a man should not be brought to justice at all than that justice should be done to him without the public being given the opportunity of seeing it done. That's how serious it is. That you had better not bring an accused person before justice than if the public will not see justice to be done. In other words, it's reinforcing the principle of equity, that justice shouldn't only be done, but must be seen to be done. And must be seen by who? By members of the country. That is the principle that was emphasized here. The state argued that the accused persons will not be prejudiced, but the public will be prejudiced. The interests of justice will be prejudiced in that the dispensation of justice will not be seen or appreciated by the public, in whose name, purportedly or ostensibly, the state is prosecuting the accused. Scenario number paradox, your worship, that the state, which is purporting to prosecute the accused persons for and on behalf of the people of Uganda, will seek to shield the people of Uganda from witnessing the proceedings. That is a travesty. Why hide the proceedings away from the people you purport to represent? It is Uganda versus it's not Odiek. Is it Odiek who? No. Benedict. So, your worship, that decision is not only persuasive, it's binding on this honorable court. The right to open justice. The judge went ahead to say, yes, in as much as it can be compromised, it's not non-derogable. Court should be cautious to look at the competing interests and the proportionality. That is the test. Competing interests and proportionality. Now, the interest of the prosecution here is to protect Odiek, not state security. And that is alien to Article 28. Actually, the proviso to Article 28, which grants the state those three elements. Article 28, that clause 2. Notwithstanding, nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press or the public from all or any proceedings before it for reasons of morality. That one is totally out. Public order, it is out. National security. My Lord, it will be your worship. It will be extremely outrageous for the state, rather for the prosecution here, we had to assert that disclosure of the identity or the face of a police officer whose warrant card is here submitted by my land friend, all his particulars disclosed, that it would be prejudicial to state security. Just one person like this. And for the record, your worship, it's not also true that Mr. Odiek Benedict is appearing before this honorable court as an IO. It's not born out of a place. No. If we were to read the contents of paragraph 1, this is how he's describing himself and the capacity in which he deposited this affidavit. I am a male adult detective No, I am a male adult detective inspector of police of sound mind attached to the Directorate of Criminal Investigations, Chibuli, and I swear this affidavit in that capacity. That is all he is saying. He is swearing the affidavit in the capacity of a detective inspector of police attached to the Directorate of Chibuli Criminal Investigations. It's only in paragraph 4 where he faintly brings in the issue of being part of the investigation, the investigating team. That Uganda Police Force took over the investigations of the case on the 11th of February, and I was one of the officers assigned to investigate the case. One of the officers. He's not the one leading the investigations. He's one of the very many police officers at Chibuli who are investigating this matter. He didn't in any way insinuate that he is the key person, the central person, that every investigations, all the investigations hinge on him, they rotate around him. Nothing. The impression that was being created. And then in paragraph says, he said, as part of the investigations, we received some items, blah, blah, blah. Your worship, I don't know whether, because if this application is granted, in essence, it means the entire investigating team handling this matter will be had results, and we proceed to the results, and we proceed to the next step of the process.
Can you rejoin the your worship? My senior colleagues said a lot, but I'd just withdraw a few things to recover. Because whatever they said at one point was redundant. I'll start with what my senior colleagues have said. The last one. He has alluded to that authority, actual authority. Whereas it would have been a very good authority if this matter was under trial. I would entirely agree. Unfortunately, the facts in the authorities he cited are completely inapplicable to this matter. The authority my senior colleague cited emanates from an application that was filed and had by a judge or the justices who were substantively hearing the matter. Josh, this is an application which relates to investigations, not the substantive trials. So the two do not speak to each other. And your worship, you are not bound by a precedent which is inapplicable to the matter you handle. And we invite you to consider it redundant. it is good that our senior colleagues, especially counsel, senior counsel, appreciated the fact that Mr. D.F. Benedict is one of the investigating officers. He ought to have withdrawn the first statement, but I think he by implication, withdrew it, where he had strongly stated that he's not an investigating officer in that matter. But with seniority, we shall not.
Then why did you even bring it up in the first place?
So, Your Worship, Mr. Odiek Benedict is an investigating officer in this matter, and he ought to be protected by this honorable court, because this matter is not under trial. I would have agreed with my senior colleagues if this matter was being heard substantive. It is not the respondents to choose for the applicant who to be the main investigating officer. And we are not obliged to make it categorically clear in any of the affidavits that Mr. Odiek is a key investigating officer. Merely mentioning that he's part of the investigative team is enough. This application is not in any way an abuse of the process. Unless my senior colleagues are arguing the fact that they are arguing that Article 28 clause 2 of the Constitution. The provision is here. And a good lawyer is one who knows where to find the law. This is the law. This is not Village Constitution Act. This is the Constitution of the Republic of Uganda, which this court subscribes. Your worship, it doesn't matter whether the press is going to wait for Mr. Odiek, unless that is a planned thing. And this is what we are arguing. Good enough defense, counsel for our respondents, are clearly making it clear that they are looking forward to identify Mr. Odiek. That is enough evidence that they are going to look for him and know who is this investigating officer. Our argument is that that alone constitutes.
Your Worship, sorry to object, but just want to advise my colleague. Submissions of counsel. Surely, Mr.
That's why I also remind my senior colleague that when he was attacking a nation building Mukavicha, it was wrong. Because the Mukavicha is appearing for the applicant.
Let's stick to the substantive
Most
matter.
obliged. We are here to respect him and not we are respecting him. My senior colleagues alluded to the fact that the public by excluding the public from this application, their rights are going to be violated or prejudiced. The right to be present in court. But at the same time, my senior colleague group answered himself for the respondent that being present in court is not one of the absolute and non-delegable rights. He mentioned, actually, he submitted and answered himself. Your Worship, the public's presence in court in any trial is not one of the non-delegable rights. And that's why Article 28, Clause 2 says they can be excluded from the trial. We just try to paint a picture that if the Constitution suggests that the public and the press will be excluded in the substantive about this application, which is emanating, or which is intended, or which is part of the investigation. I think this is the best time for court to exclude the public and the press. Because then they will have then a right to be present at the time when the substantive trial of this matter is on. The substantive trial is not a substantive trial. What prosecution mentioned this project because the defense mentioned his name in the first day. They said we would like to have Mr. Odiek Benedict be present in court on the very first day. If my senior brother could memorize that. And that's why we were able to speak and mention his name. Your Worship, it is not true that the respondents are addressing these questions. Defense. It is the defense. In any case, what we are here for would have been here basically for retention. Otherwise, applications for access, imaging, those are expanded. So, it is something, Your Worship, that this court can
We did not talk about the nature of the application
That's actually
in
true.
inter-parties. But again, if my colleague reads
It's okay, we withdraw it.
Section 21 of the Data Protection Act, you will find that it's an application which is inter-parties. So again, correct.
Your Worship, it's a minor correction. Your Worship, my senior colleague Banga tried to address this court in respect to the authority that we laid upon. The Sun Yen King Kong Congo King case. My senior brother also hid away from court the fact that court was on record for mentioning the issue of protecting witnesses and evidence. And it gave exceptions under which that can be done in the same case. I agree with him that the principles therein were emanating from an application by prosecution who did not want to disclose. However,
sorry, the principles emanated from constitutional reference. My colleague is lying. It was a reference from a trial before the Honorable our Stella Anabilis in the Magistrates Court at Uganda Road. The reference made under Article 137(5)(b) of the Constitution of the Republic of Uganda, where the state had refused to make a disclosure prior to the accused person taking plea. The state, in that case, did not apply. It was the respondent, it was counsel who applied for the disclosure. So the state has never applied. It is important that counsel is truthful, or shall ask him to submit on oath.
I think the issue was about disclosure, which we have mentioned. I think my senior colleague still wants the microphone, but we shall keep sitting down and the addresses. The issue was about disclosure. which we say.
Proceed, Counsel.
Your Worship, it is therefore this court's duty to protect Mr. Jack Benedict and the integrity of the investigations from morality and public order, and also national security.
Say that again. Protect it from.
The reason why the public and the press, the reason why the press and the public are excluded are for three reasons: morality, public order, and national security. I think, Your Worship, that marks our agenda. We made this court. We made this court, Your Worship, to allow the application. So,
Shall be prejudiced in any way, given that since it's still at investigations level, so this is the decision. Having heard from all parties concerned, this court takes cognizance of the fact that this is an application arising from the investigations in the murder file, wherein the two accused persons are charged with a capital case and not a substantive hearing of the said capital matter. Court is also alive to all the authorities that both the state and defense have alluded to, and agree with the defense that they are binding on this court. However, this would only occur if the facts or circumstances were similar, which isn't the case, and therefore not binding in this matter before court today. Yes, an accused person is entitled to a fair, speedy, and public trial, and the exception to public trial being for reasons of morality, public order, or national security. In the case before court, given the nature of the charged offences and the fact that the matter is still at investigations level, it's only prudent that for the integrity of the investigations to be upheld, so that morality, public order, and national security can be maintained, this application be had in camera, as no person, that is the accused, and public, shall be prejudiced in any way, given that since it's still at investigations level, when the investigations are complete, full disclosures provided for in the monuments in case can be sought and used as wished by the defense. So the matter is going to be had in camera in the next 10 minutes.
We have an application. Your Worship, we appreciate the ruling of this court. We have instructions to apply for revision of your decision. For an update. Your Worship, under the proceedings of Section 33 of the Agriculture Act, Section 48.
Section what?
Section 33 of the Agriculture Act,
Yes.
and then section 48 and 50 of the Criminal Procedure Code. We are also adding section 17.1, the Judicature Support section 17.1 and 33, as well as section 48 and 50 of the Criminal Procedure Code Act, and rule 2 of the Judicature Criminal Procedure Applications, which grants rather the right to an aggrieved party in any matter to seek for revision of any report made by this honorable court. So we do so pay your worship. The applicants be granted, rather the respondents be granted their right to seek for the remedy at another court and go to division. And we pray that you please to stay the proceedings until the application is disposed of. We also pray that your worship, this honorable court provides us with the entire record of proceedings, the ruling itself, and the entire certified record for that particular purpose of your worship. Your worship, this application in our opinion goes to the root of the dispensation of justice, and the great concern was that your worship, if we proceed in this manner, there is likely to be a miscarriage of justice. As you have observed in your worship, that we are at a very critical stage of gathering evidence. And if there is any non-compliance with the procedures and all the rules guiding investigations and evidence gathering or assembling that the evidence against the accused person will be highly prejudicial and professionally discouraging. So we pray that that importance be appreciated by this honorable court, and our prayer is done. So the emphasis is in section 48, power of this court, by the court, call for the record and have it reviewed or revised for applicable orders within.
Daily updates. How much do you give in here? Twale gwe daily updates. Kajanja katwale wa mama wo gwe daily updates owulidde. Daily update. Bw'oba olina maama wo akajanja katwale wa maama wo owulidde. Daily update, take that stupidity to your mother. Daily update, okay? We are standing over for 30 minutes, getting back. Fande, good morning. We are getting back, coming back in 30 minutes from now. It's been a standover for 30 minutes, getting back in 30 minutes. Okay? For the President Jebali so kamubuze ko katono nnyo mukama wange. President dakiika emu yokka tusoke tujjemu mukama waffe tayagala bifaananyi. Tubulireko olwaleero tukulaba ku kooti ya Dr. Kizza Besigye.
Dr. Kizza Besigye esooka olwaniriza Uganda.
Yes, sir.
Ate n'okuba nabyabufuzi babakulembeze abalwanirira eggwanga limu. So nga tumuyita mukulu waffe mu kintu kino balina okubyanjibwa era tugambe olabe nga bamuyita kubanga like any other Uganda. So, as we are National Revival Coalition and coalition everyone, so and our purpose is to make Uganda better. Uganda cannot be great when there is a lot of injustice, when there is a violation of human rights, when they are kangaroo and so we are trying our best. That's why we have done
the matter which was in court of taking this matter into the chambers, what is your take about that?
My take about it is
that the witness wouldn't need the public eye. He could be insinuated, he could be abused, he could be killed, yet he's a police officer.
You know, in most cases, where kangaroo courts are, where there is no justice, even the witnesses are hidden because they are not certain of the facts. What they will do, they will create a situation that will ensure that evidence was there to get it there. We've been seeing different because that is reality. We justify the proceedings, but if the defense, that means whatever they are using not to win.
That is Katumba. Should Ugandans expect you to come back for the president's? Yes.
Because the voice of the young people should be heard. And our purpose is to go and
kale kooti wetu bwetambudde eya Dr. Kizza Besigye bwetyo ekyatambula abajulizi beeti okuwa obujulizi ate nga bakakasa nti nno balina obujulizi kasi tumanyi lwaki omuntu aba alina obujulizi aba yeekweka nga takkiriza kubuwa mu lujjudde nga byayogera bya ddala biba nga si bipangepange ne katubine tujja kuba tulaba ki ekinaba kigenda mu maaso.